Good day, everyone, and we are on our fifth lesson, and it's about land acquisition. And before I begin with our first slide for this lesson, I just want to say thank you to those who liked and continuously follow the Facebook page, and also those who subscribed our YouTube channel. And now we begin the lesson with the following presumptions because the sale of a parcel of land is really a complex transaction under the law, and it depends. There are so many factors that would really affect the transaction, and also would affect the requirements needed for transfer. Now, these are the following um, presumptions so that you will be guided in effectively learning and understanding this lesson. Now, the land subject of the sale should be alienable and disposable. For law students, you are very familiar with this, that there are constitutional and legal requirements or limitations as to um, whether the property or the land could be owned by a person or not. And you have to remember also that there's no lien or encumbrance, or there's no mortgage attached to the property. And you also have to know that the title of this is not a patent or based on a patent, and it is not under agrarian reform and even under irrigation law, because the requirements needed for transfer would vary, and there are legal limitations. For example, a patent, there's a type in which if a patent is granted, there's no disposal allowed within 5 years from the grant. So you have to take note of all of these. And you have to take note that what as among the presumptions here would be the land involved has an original or transfer certificate of title, and you're not only looking at a tax declaration. And it is a it's a misconception that if there's a tax declaration issued to the property, it means that the holder or the tax declarant is the owner also, because a tax declaration by itself is not proof of ownership. What is the proof of ownership is a title, whether it's an original or transfer certificate of title. And you have to remember this very important presumption also, that the sale is valid in all its aspects, and you know the elements of sale, that there's a the capacity of the parties, there's a valuable consideration, and there's a transfer, like an exchange of a property, and also the payment of a price. And also we have to consider that the notarization is regular and there's no defect at all. Okay, so we begin with the usual process. Actually, the I divided the usual process in the acquisition of a parcel of land into three: prior to the execution, during the execution, and after the execution of a contract of sale, because we're talking about a sale. So what is involved here is plainly a deed of absolute sale. Now, before the execution of a contract of sale, especially if you are the buyer, you have to conduct technical and legal due diligence. Why? Um, it's possible that the property you are buying is non existent, or there are problems under the law based on the documents that you will acquire. And it's a possibility also that taxes are not paid, like real property taxes, or there's a prior transaction that would halt the the existing or the current transaction now. And you have to remember that again, not all lands could be alienated to a private person. For example, those protected areas or landscapes in which no sale is allowed. And you have to conduct, it's really my advice that you should conduct an ocular inspection of the land, especially those Filipinos working abroad. They just trust their relatives here, they just send the money so that the payments will be made, and all the while there's thinking that they already paid the property, and only to find out later that the property is non-existent at all, or the property is already under the name of another person. So we have to avoid these mistakes. Now you have to ascertain also the capacity of the parties prior to the execution of the contract, because it's possible one could be a minor or has a mental incapacity or under guardianship, or even the seller has open cases in the BIR. This means that there were prior transactions, or the party or the seller has a business and it's not he is not compliant with the payment of taxes. Now, during the execution of the sale, you have to conduct the notarization, and you have to be very particular of this because you have to make a good timing, because in case you will have late payments for your taxes, penalties, surcharges, and interest will ensue. So you have to be careful on this, and you can trust your lawyer on this, or the notary public, to explain you on these things. And you have to consider also during the execution of the sale how the payment will be made, whether cash or through a check, or you do that in the bank, or other safety considerations, especially if the price involved is a huge amount. And you have to consider the delivery and acceptance of the land. Although under the law, the title is a representation of the land itself, so the delivery of a title is delivery of the land itself. Now, after the execution of the contract of sale, you have to pay the relevant taxes, and you have to know the deadline. And I will allot a specific lesson on taxes attached to acquisition of property, or the sale of a property, especially if the same is considered as a capital or ordinary asset. Now, you have to also consider the processing of the tax declaration and original certificate of title, because once there is a contract of sale already, payments were made, and the process actually does not end there, because you don't have your a tax declaration or a title under your name. And you have to safeguard also the land, especially if, although there is a sketch plan, although there's a survey plan, you have to remember that um, there could be illegal settlers or intruders of the land, and you have to protect. And fencing is a good way of protecting your right as an owner, especially if you are the buyer. So we'll just have a 1 minute break, and we will resume in a while. Thank you for listening, and see you.